So my first question is, the original contract need not be performed if there is A. Novation of contract, B. Rescission of contract, C. Alteration of contract, D. In all the above cases. When does a contract need not be, when is it required to be not performed? The performance is not mandatory, not required. In novation, in rescission, in alteration, or in all the cases. It's all the cases, because in all of these cases the old contract gets discharged or cancelled, so it is not required to be performed. Okay. When an inferior right accruing to a party in a contract merges into a superior contract accruing to the same party, then A. The contract conferring the superior right is discharged. B. The contract conferring the inferior right is discharged. C. Both contracts are discharged. D. Both contracts. C. Both contracts are not discharged. D. Both contracts are discharged. What happens when an inferior right, when a smaller right gets into or merges into a superior right or a bigger contract? The smaller contract, the smaller right gets discharged. So the answer is, the contract conferring the inferior right is discharged. The original contract of a smaller right is discharged. That's the answer. Next, acceptance of consideration lesser than agreed is known as A. Rescission, B. Novation, C. Remission, D. Alteration. It is remission. Let's check. That's the answer. Now, I had told you in remission we have two parts. One, a lesser consideration is agreed. Two, the time given for performance is increased. So, in either case, it will become remission. Next, dash of a contract taken place when all or some of the terms of the contract are cancelled. A. Novation, B. Alteration, C. Merger, D. Rescission. When some terms of the contract are cancelled, what happens? When some of the terms of the contract are cancelled or changed, what happens is alteration. You alter the contract. That is the answer. The process by which one person succeeds rights, interest, and benefits and obligations of another is termed as. Now, this is pertaining to the topic succession and assignment. There we had done when the rights and liabilities of a person get devolved to another person, generally after his death, it is termed as succession. Because in assignment, only the rights get transferred, only the interest gets transferred, only the benefits get transferred. The obligations cannot get transferred in assignment. Only in succession can the liabilities, the losses, and the obligations can get transferred. That's the answer. Next, Brown promises to sell his house to Crown for 20 lakh rupees. Later on, both of them agreed not to execute the deal. This is known as A. Novation, B. Remission, C. Rescission, D. Alteration. Brown and Crown enter into a contract, and later on both decide that the contract need not be performed. So in effect, what are they doing? They are cancelling the contract. And when you cancel the contract, it is called as rescission. Okay, rescission is the answer. Next question. A holds a house on lease. After that, he buys the house and became the owner. The contract is discharged by A. Rescission, B. Merger, C. Waiver, D. Remission. A took a house on lease and later on he bought it. So now, what is happening? Uh, an inferior, a smaller right, a smaller contract is combining or merging into a superior contract, into a bigger contract. That is called as merger. We had already discussed this example when I was explaining merger. This is called as merger. That is the answer. So this brings us to the end of the topic mutual agreement. Till now, we have discussed how a contract is performed and under how following points have been covered: actual performance, attempted performance, discharge of contract, and mutual agreement. So, in the next session, we'll see what is lapse of time, what is operation of law, what is impossibility of performance, time and place of performance, and some incidental topics to how the contract is performed.